In this installment of Washington Legal Foundation's Legally Brief, we are joined by Stephen Murphy, a partner in the law firm Reed Smith, who will share his thoughts about the broader implications of the recently finalized FTC antitrust enforcement settlement with Intel. Mr. Murphy, FTC pursued Intel's use of loyalty discounts and bundled pricing for its purchasers as an unfair trade practice under Section 5 of the Federal Trade Commission Act. What's significant about the Commission's use of that particular statutory provision against Intel's conduct?
I think it's very significant. There's been a period of time over the last decade where the Federal Trade Commission has not been particularly active in the bringing of Section 5 cases. I think that has been largely a factor of 3 Court of Appeals decisions which have refused to enforce FTC acts and orders in connection with Section 5 complaints. The first case, the Second Circuit's decision in Official Airline Guide, refused enforcement of an FTC order on the ground that the action taken by the OAG did not cause any competitive injury, and they were not in competition with the purported injured parties. In the Boise Cascade case, the Ninth Circuit dealt with a delivered pricing system and found that there was not sufficient evidence of collusion in that case to warrant enforcement of the FTC's order. And then finally, in the Ethel decision, the Second Circuit, again, this is a case dealing with delivered pricing systems, but also most favored nation clauses and other conduct, again found no evidence of collusion or of injury to warrant enforcement. These 3 cases are in the face of almost 75 years of consistent Supreme Court decisions, giving a very broad balance to the scope of Section 5 and making it quite clear that the Congress intended that Section 5 would go beyond conduct which is violative of Sections 1 and 2 of the Sherman Act and Section 4 of the Clayton Act. Now, I see this as the Intel case being a move towards further Section 5 enforcement, largely because of the role of Chairman Leibowitz, who in his concurrence as a commissioner in the issuance of the Rambis complaint in 2006 was very forceful and very vociferous in his language in terms of that the conduct engaged by Rambis would also have been a Section 5 violation. The Rambis complaint was limited to violations of Sections 1 and 2 of the Sherman Act. And so what we're left with is a desire on the part of the chairman to go forward and the staff being given support in bringing Section 5 complaints. Now, one thing that the Commission staff is going to have to deal with is the comment by Commissioner Ross and his concurrence to the issuance of the Intel complaint, where he chastised Commission staff in terms of having added allegations under Section 2 of the Sherman Act to the Intel complaint, when he believed that the conduct described in the Intel complaint was purely violative of Section 5 and that there was no need to have any additional allegations under Section 2 of the Sherman Act. You know, time will tell how the staff deals with that, but the settlement obtained suggests that there is wisdom in still adding the Sherman Act violations.
Should market leaders in the technology industries be concerned about the Commission's focus on Intel's potential use of patent infringement suits and FTC's required remedy in the Intel settlement that Intel altered intellectual property agreements?
I don't think so. And I say that from the perspective of the Sherman Act. The Supreme Court has made it clear in its North Pennington doctrine that individuals and corporations are entitled to petition the government in a broad range of arenas, including the courts, for redress. And the only exception or defense to that is where a petition or complaint in court is deemed to be sham. And so in this case, if there had been a material allegation in the Intel complaint about the filing of sham litigations, I think there would have been a very difficult burden of proof. The interesting thing about the Intel complaint, however, is that there really is no substantive allegation of improper patent infringement cases being filed. There's a reference to withdrawal of indemnifications for Intel's customers from patent infringement cases. And in the request for relief, there is a demand for an injunction against filing of patent infringement cases by Intel. But there's no real substantive allegations in the complaint itself about that. Now, the settlement agreement does have very substantial references to changes that need to be made with respect to Intel's patent agreements, and the order requires Intel not to be filing, improper patent infringement cases. Obviously, Intel was comfortable with that because they agreed to that even in the face of any lack of substantive allegations in the complaint. I think in terms of how high-tech companies and others which are patent-intensive industries, there shouldn't be such a concern. For whatever reasons Intel had in agreeing to the settlement, I don't think that will necessarily be repeated, particularly in future cases, particularly in the absence of fairly substantial allegations of abuse of the petition of the government as protected under the Norr-Pennington Doctrine.
How did the FTC look at Intel's use of bundled discounts in this action? And was there a perspective in the case in line with how federal courts have looked at these issues in terms of whether or not bundling is unlawful under antitrust laws? Well,
unfortunately, in the United States, there's really no fixed rule in terms of what type of bundling violates the antitrust laws. The Supreme Court in Burke Group looked at predatory pricing and found that in order to have predatory pricing, you'd need to have pricing below average variable cost with a high likelihood of recoupment. In terms of bundling specifically, two courts of appeal decisions have come up with somewhat different views of what constitutes unlawful bundling. The Third Circuit in LePage's found that certain 3M activities were not violative of the bundling rules, but would not come up with a decision in terms of what the standard should be as to what conduct would actually constitute unlawful bundling. The decision of the Ninth Circuit in Peace Health presents a different picture. And in that case, the Ninth Circuit decided that a pricing below average variable cost would be required, and that particularly in the case that they had, there was an ability on the court to differentiate which product was being bundled, and the court required that all of the discount, all the bundled discount, be attributed to that particular product in terms of determining whether there was pricing below average variable cost. So just even laying that aside for the moment, the allegations in the Intel complaint are very rote. It simply says below some measure of cost with a high likelihood of recoupment. But in one place, there is a statement that the below cost standard that the Commission is using is below average variable cost with some further consideration of contribution. And so this is somewhat of an amalgam between Burke Group and Peace Health. And so it is a thoroughly defensible position from that perspective, and it's likely to be one that the Commission carries forward.
Mr. Murphy, thank you for participating in Legally Brief.